Speaker is Kimberle Crenshaw, and she will contextualize Whiteness as Property in terms of where precisely CRT was at the time that Whiteness as Property was published and how Whiteness as Property articulated some of the themes that were emerging at the time. Professor Crenshaw is a distinguished professor of law at UCLA, and though we don't like to admit it, we share her with Columbia Law School, where she's also a professor of law and the executive director of the Center for Intersectionality and Policy Studies. Many of you are familiar with her groundbreaking work on intersectionality. Many of you are familiar with her work on equal protection and legal ideology. Many of you are familiar with the constitutive role she's played with respect to CRT more generally. You may not know that she's done quite a bit of international human rights work in Brazil, in India, in Africa, in Latin America, and under the auspices of the African American Policy Forum have been engaged in a range of civil rights debates. Please join me in welcoming Professor Kimberle Crenshaw.
Thank you, Devon. Good afternoon, good evening, everybody. It's really a pleasure and an honor to be here. There are so many things I was going to say, but this guy scares me with this 15-minute thing, so consider me saying pleasure, honor, great, I'm happy, and I want to get into it. So as it's increasingly been the case with advancing age, I'm stepping into the role here as the griot, telling one of the many possible stories that one could tell to contextualize and make some observations about the person and the work that we're gathered here to celebrate over the next couple of days. Luckily, though, I'm not the senior griot on this panel. I'm happy to say that as long as Neil is around, I am the junior person in this conversation. So it's really a special treat to be one of the old heads, one of two old heads in this conversation. So in thinking about some of the possible points of entry tonight, I was prompted to think about the placement of whiteness as property. Whiteness as property. I like WASP. I'm going to go with that one. In the Red Book. As many of you know, it appears in the fourth section, the doctrinal section in the book, along with Chuck's article on the intent standard, Lonnie's article on race-conscious districting, and of course Neil's article and Derek's on racial realism. Now, of course, it could have been positioned in any number of ways, but the very nature of building a collection creates a certain determinism. It's like an old steel black and white picture where everyone is just where they happen to be. And so what I want to do is to use one of those conventions that you see in movies when they're going to tell a backstory. So look at the black and white picture and suddenly it starts to flicker on the edges and there's the harp sounding. And we're going to go back to the past before the picture was actually constituted so you can get a sense about where it fell in line and actually what was happening at the scene before it actually came onto the scene. So I'm going to try to retell a story by basically imagining the position of critical race theory before Cheryl Harris came onto the scene and whiteness as property did the work that it did. And to do that, I'm going to interrogate three different spaces. I hope I get to three different spaces: liberal institutional practices, liberal race scholarship, and critical legal studies. I hope to say a paragraph about each one of them. I'm going to be painting really broadly here. For those of you who have read the introduction of the Red Book or the Connecticut Symposium, you know some of these moments, but I want to emphasize here some of the hanging chads of those moments, some of the things that just hadn't quite been resolved really until whiteness as property came onto the scene. CRT was a product of discursive struggles, institutional struggles in the 80s. The earliest generation of CRT people came onto the scene in the 80s. A lot of us felt like we were in the officers' club on the other side of the war that was going on against civil rights. There were new rules that came on the scene without much contestation in the law schools, like Washington versus Davis, that effectively insulated the racial status quo from any litigation-oriented efforts attitudes to fundamentally dismantle these institutions. And then as Devon pointed out, Bakke versus Davis Medical School, which limited the extent to which state institutions would be able to address some of the contemporary consequences of segregation. There were, for many of us, doctrinal and institutional wars going on, and it was clear that not only were we losing it, we were, to be frank, in pretty desperate shape. We were behind enemy lines, our weapons were still in development, our supposed allies were, to say the least, conflicted and prone to taking us out with friendly and sometimes not so unfriendly fire. And after a fairly public and sometimes embarrassing shootout, it wasn't clear whether reinforcements would actually be coming. So for many of us, it could be that this was the first and last class of critical race theorists. Now, the conflicts with our allies placed us in need for new and more critical weapons, and that need was placed in sharp relief when we looked at the question of merit. So liberals, as well as conservatives, for the most part, understood racial power in terms of racially discriminatory attitudes and behavior. That is to say, deviation from neutrality. Rationality would prevail over the bias of thought and action. And as this translated into debates about diversity or affirmative action, it created a contradiction for some of our liberal allies that was at the core of their thinking. On the one hand, their belief in this neutrality or this idea of merit obscured their ability to see racial power playing out in the standards that they used to justify the largely segregated institutions that they occupied, convinced that so long as race was not explicitly a criterion for inclusion, the outcomes were not in and of themselves a manifestation of contemporary injustice. On the other hand, integrating institutions was a liberal aspiration, which created a contradiction. To actively integrate American institutions, race would have to be taken into account. But to take race into account was considered to be engaging in bias, albeit bias in the name of good. So the willingness to sit with this contradiction, or I would say unwillingness to confront it, is expressed through what I call the evolutionary idea of pool watching. Academic faculty steadily watched over the pool in hopes that some unknown specimen would emerge magically ready to be hired. So efforts to contest this notion of merit were constantly rebuffed, even by civil rights leaders who saw in the insistence that race be taken into account a reversal of everything they worked for. So for them, colorblind neutrality, which for them is what integration has had to navigate, repudiated biases on both sides. The Klan is here, the Panthers are here. White nationalists here, black ones over here. And the whole point was to find a way to navigate through these extremes with neutrality. Now, moving in tandem with this institutional hiring practice were scholarly practices. They moved from a similar point of departure, namely, presuming that the factors and the values that had played a starring role in constitutional jurisprudence to date were race neutral. So those are ideas like federalism, existing entitlements and expectations, and societal security policies that were that already were in place. So the brilliance, for example, of Derek Bell's scholarly leadership was his willingness to ask a different question. If dismantling white racial power is the goal, in what ways are these standard constitutional values the embodiment of the very problem that we're trying to interrogate? How is the maintenance of white power held within values through which equality discourse is mediated? Now, here was a hint at what was needed, but not yet its articulation. The questions were raised, the stance, one that was situated outside of the taken for granted foundation of most constitutional jurisprudence. It was now imagined, but no one had yet come onto the scene who could imagine, much less articulate, a comprehensive reframing of law's relationship to racial power through its construction of whiteness. It was, unbeknownst to us, a twinkle in Cheryl Harris's eye, but we didn't know Cheryl Harris yet. So back at the farm, there was another scene with a deeper articulation of law and racial power being debated. This was critical legal studies. It was the place where converging progressive and left projects got together. It was vibrant, it was vital, it was crazy, it was fun, it was controversial, it was all that good stuff. But it was also largely a white space, and one which quite predictably did not respond entirely positively when the few people of color within its midst put to them a very specific question. What is it about the whiteness of this organization that keeps people of color at bay? Now, I've told the story many times about the apoplectic reaction of some of the CLS heavies, and in some ways, CLS was never the same again. But here I want to underscore the narrow thinking about race that preempted the extension of CLS's thinking about law and social hierarchy to race. So as it emerged in many of the debates within CLS over the critique of rights, and more specifically, the allegation that any race project was inherently essentialist, was the notion that race, to have explanatory force, should presumably find a fixed expression across space and time. So race was, absent that fixedness across race and time, not real in any sense that it could function as the core of an intellectual or political project. Now, this was a puzzle for us, given that the most vocal critics were at the same time deeply invested in debating law's role in producing class hierarchy.